Welcome to Advocating for Dads with Jana Jones.
Hello and welcome to Advocating for Dads, the podcast where we dive into family law issues and provide practical advice to fathers navigating the complexities of custody, divorce, and separation. I am your host, Kevin Rosenquist, and as usual, we're joined by Jana K. Jones, a dedicated family law attorney who has been serving fathers in North Carolina since 2009. In this episode, we're going to discuss an essential legal document that every father should understand, the separation agreement. Jana, welcome back. Great to see you.
Great to see you as well. Thanks so much.
All right. So what exactly is a separation agreement in North Carolina, and why is it an important document for fathers going through a divorce or separation?
Sure. So a separation agreement is essentially a contract, and it is drafted in order for the parties, two spouses, to decide how they want to deal with assets, liabilities, and custody and child support issues related to their marriage and the demise thereof.
Okay. And how does that differ from other legal documents like divorce decrees or custody orders and those types of things?
So because it's a contract, it's not filed anywhere, it's not registered anywhere, it's a private document. Whereas custody orders, judgments of divorce, et cetera, those are orders of the court, those are in the public record.
So when do those documents become into play and is in the process?
Sure. So the point of a separation agreement is to figure out how to split up assets and liabilities and talk about custody and child support issues without having to go to litigation, without having to go to court and get court orders. So the point of it is to try to make that as streamlined as possible, to keep it private again, and to be a little bit less litigious and combative. Separation agreements are typically only going to work for parties that are more or less in agreement about what they want to do. Maybe they need to parse out some details. Maybe the math needs to be done to figure out how we distribute different assets or liabilities. But for the most part, they're both committed to wanting to get things resolved without going to litigation.
That's why the agreement is in the term, right?
Exactly. If you don't agree, then you have no separation agreement.
That's true. That is true. And is it possible to do a separation agreement even if the parties may be a little bit, I don't know, like not totally getting along?
Yeah, I think it is. It definitely is. It's always worth a shot. It's going to be less expensive and less litigious and generally more amicable approach to dealing with the dissolution of the marriage. So it's worth a shot if you've got a couple of things that you know you can at least start from and then work from there to hopefully build into a comprehensive agreement. So I always recommend that as the first option to consider. Sometimes it's not going to be practical, but if it's a possibility to get things resolved through a separation agreement, that's typically going to be the best route to go.
And how does it work? Each party has their own attorney, and do the attorneys try to hash it out together, or does everyone sit together? How does the process work?
Yeah, so generally speaking, it depends on the complexity of the estate and what the parties are trying to do. If we have an estate where there's, multiple accounts, there are retirement accounts, there's homes, cars, a relatively middle class to high upper middle class or more estate, then it's going to be helpful to have attorneys involved because we can do an asset chart. And what an asset chart is labeling out what are the assets and liabilities of the marriage, talking about the value of them on date of separation, and figuring out how we can do a 50-50 split, which is generally the standard in North Carolina. But obviously, because this is an agreement, the parties can agree to some other type of split. So maybe a 25-75 split or 45-55 split, something like that. It's really up to the parties as to what they want to do. But we generally will start with an asset chart so that we can understand the estate and figure out how to split from there.
What are the key components that fathers should focus on when negotiating a separation agreement in North Carolina?
So I think the most important thing for fathers to understand is, and really anyone to understand, is that with the separation agreement, it is a legally binding document, okay? So even though it's not filed in court and it's not a court order, as it relates to equitable distribution and alimony pieces, whatever you sign and notarize in a separation agreement, assuming your separation agreement was properly constructed, will be binding. And if someone violates the terms of it, you have the option to go to court and sue for specific performance, asking that the court enforce your contract, okay? But when it comes to custody and child support provisions that are included in a separation agreement, those are, I don't want to say wishful thinking, but they are a commitment by the parties at the time, obviously. But if somebody decides to change their mind about custody and child support, court, either one of them have the right to go to court and sue over those issues until the children turn 18 and graduate from high school. So, assuming the parties truly do agree about what they want to do about custody and child support, and that is resolved in the separation agreement, then there would be no need to go to court on those issues. But if somebody decides to change their mind on them, you always have the ability to go to court and deal with custody and child support, because that's best interest of child. And you can't contract out of that. So the court will always consider that.
Okay. And what advice do you have for dads to ensure they have a fair agreement as it relates to child custody and visitation?
Get good advice from an attorney. That's always the first step, because everybody's situation, is different. You may have some friends who went through a divorce, and with the kids, they ended up doing joint custody arrangement. And so you feel like we should do it too. But there might be some facts or circumstances that are particular to your situation that don't make that practical, right? So it's not a one size fits all. And so it's really important to get legal advice to understand what is best and what's realistic in your specific situation.
Can you speak to the process a little bit as far as how the divorce process goes when you have that agreement and when you don't have that agreement? Obviously, that's a big, huge question, but are there specific things you can point to that so this is what happens if you have it and this is what happens when you don't?
So yeah, essentially the difference between the two is if you have a separation agreement, there is no need to go to court and litigate over equitable distribution and alimony, because those issues have already been dealt with in your separation agreement, and you're legally bound to those. So if someone were to file for equitable distribution or alimony, your defense is, hey, we've got a contract, Exhibit A here. This has already been resolved. And the court's going to say, you guys have to follow your agreement because that is what you guys agreed to do. And one thing to note, I don't know that we've discussed it yet, but the important thing with a separation agreement is that it must be signed and notarized. Just a signed contract or agreement between parties is not going to be sufficient. It must be notarized. Okay. But going back to your question, so that's the power of having that separation agreement. You're just going to need to do your uncontested divorce, which you will not be eligible for unless you've been separated at least a year and a day. Then you can go ahead and file for your uncontested divorce. Conversely, if you do not do a separation agreement, you're kind of in a situation where you don't know what's going to happen. So let's say a year and a day passes, you file for your uncontested divorce. When the other side gets served, you're not going to know whether or not they're going to, do an answer and counterclaim, bringing in claims of equitable distribution and alimony, because those issues have not been rectified yet. Mm-hmm. So you ideally want to get a separation agreement done, if you can, as soon as you can after separating, so that those issues are resolved. And then once you've got your year and a day, you can go ahead and file for your uncontested divorce. And then it's mostly an administrative procedure at that point.
Curiosity question. Why a year and a day? Why is it important to have that long of a separation before you can actually file for divorce?
So that's because that's what the state of North Carolina requires. Yeah. That's the short, easy answer. North Carolina's in the South. And so, they are hoping that because they're making you wait so long to file for divorce, maybe you will reconcile. That was the mindset behind setting that 1 year requirement, and it hasn't changed yet. It's come up quite a few times to change that, to shorten that, because it's really not practical, especially for folks who don't have a lot to fight over. Right. It's pretty simple, and they just want to get their divorce and move on. And unfortunately, they're stuck having to keep up with each other for a year because you've got to get that person served. So you got to know their address. And if it's a particularly rough situation, you guys aren't amicable, you may not want them to know your address. You may not want to give out that information. You may not want to have to find them a year later. But unfortunately, that's how it works in the state of North Carolina.
So is it fair to say then in certain situations, it makes more sense just to go right to filing for divorce and not do the separation agreement?
No, I wouldn't say that unless the estate is pretty much non-existent. If you guys were renting an apartment or renting a home, cars are titled in individual names based on individual incomes. You never gave each other money to maintain your standard of living.
Maybe no kids.
No kids. There's no debt, no assets either. Then you don't have anything to gain or lose by doing equitable distribution or alimony. So in that situation, no, you don't need a separation agreement. You just got to wait your year to do your divorce.
Okay. The process, is it longer when you do a separation agreement then?
No, because you can get that done during that, 1 year waiting period, right? You can't force that or move that any faster. Once you've separated, that's when the clock starts, but you cannot file until a year and a day. So, unfortunately, you've got to wait that time period. So utilizing that time to do your separation agreement is your best bet. That way, once you are eligible to file, ideally, you've already dealt with all issues related to equitable distribution and alimony.
Okay, I think that's probably where I was confused then. So either way, whether you do it or not, you have to wait a year and a day?
No matter what.
Gotcha. Okay. Okay. Yeah, I could see that causing some problems for people.
Yeah, absolutely. Yeah. And it is definitely best to do a separation agreement sooner rather than later.
Yeah.
The longer you wait to do it, the more difficult it becomes to get documents related to your date of separation because, certain banks or certain accounts might not have information 5 years back. So if you're separated all these years and now you want to deal with equitable distribution issues, that can prove challenging, right? So the sooner you can get started on your separation agreement, the better. And ideally all that is parsed out, done. And, let's say one of the parties is refinancing a house or buying the other person out by a certain period. Those things can already be handled. And then once you're eligible to file for that uncontested divorce, that is the last you have to deal with each other.
Is there anything not that doesn't get included in a separation agreement? I mean, it seems to cover all the bases, kind of.
Yeah,
even when it comes to child custody.
Absolutely. That's the goal with a separation agreement, to deal with all issues, just a global settlement of everything that comes up. I've done separation agreements that deal with pets. I've done separation agreements that get down to spices. So any and everything can go into a separation agreement.
We've talked before about, mediation and things like that. And if the parties aren't really agreeing, and the separation agreement doesn't look like it's going to happen, can they go to mediation to help push the separation agreement?
Absolutely. And that's a common occurrence. Some separation agreements don't require that, but in some scenarios, depending on where the parties are, a mediation is ideal. So in North Carolina, you're going to have to do mediation before you can do an equitable distribution trial anyway. And by doing mediation early on, you can kind of see whether or not, you're going to need to go down a litigation road to begin with.
Right.
So I say that's generally more important for people who have a more complex estate, or for people who have particular mindset on custody and they just need a neutral third party to talk them through, exactly why they're wanting to do what they're wanting to do, and to see if there is some way to meet in the middle.
Your practice focuses primarily on dads, or exclusively on dads, perhaps, right?
Primarily on dads.
Primarily, okay.
I'm happy to represent moms as well.
Okay.
That is a common misconception, but I am father focused because I feel like a lot of times in family law, for a number of years, the assumption was always mom's always right, the wife's always the victim, and that can be the case in some scenarios.
Of course.
That's not always the case, and so I'm just trying to balance the scales, if you will.
Yeah. Yeah. So in your experience, do you feel like it helps fathers significantly when a separation agreement is in place?
Yeah, I think it does, because it gives everybody kind of the rules of the road, right? We know what we're doing. We know how we're splitting this up. We know what we're taking on. People have the ability to start making plans now for what life is going to be like after this chapter is over. And so it just provides some finality. And then you're just, like I said, waiting. If you haven't already got that year and a day of separation, then you're just waiting to get your uncontested divorce to finally be clear about it all.
What if there are situations where the parties can agree on everything for a separation agreement, but not one sticking point? Maybe it's child custody or something like that. Can you do just like sort of a partial agreement where you just put in everything you agree upon and then you're going to have to fight the rest of it out later?
Yeah, absolutely. You definitely could do that. And I would say that that's the best way to do it along those lines. So if we're going to do a separation agreement, we need to be dealing with equitable distribution and alimony completely. Mm-hmm. Otherwise, we might as well just litigate. But if custody and child support either are not an issue because there are no minor children at all, right? Those separation agreements aren't going to have anything as it relates to custody and child support because there are no children. But if it is a situation where the parties do have children, but they have an agreement about how they want to handle that, or they want to kind of kick that can down the road and see what happens, maybe they're just fresh off of separating and they're not quite sure how they want to handle custody and child support, then it's perfectly fine not to include those provisions in the separation agreement. Like I mentioned earlier, while you are bound by what you agree to as it relates to equitable distribution and alimony in your separation agreement, it's not the same thing with custody and child support, because the court will always consider the child's best interest. You can't contract out of that. So at any point, the parties can go to court and deal with custody and child support issues.
Any examples of one of the strangest or funniest things you've seen included in an agreement?
I think the spices one was new for me. I had a client who is particularly invested in the spices that he has.
You're talking about food, spices to cook with.
Absolutely. Absolutely. And he did not want to go out and have to buy new ones. And so he wanted spices included in the separation agreement. That was a first for me in 15 years of practicing. But hey, he made a good point, right? You don't think about as you're cooking and you just need poultry seasoning or Laura seasoned salt or something like that random. It's no big deal. It's a couple bucks. But if you've got to create a whole new spice cabinet, depending on the types of spices we're talking about, that could be expensive. And he's like, why do I need to drop another $200 when, some of these spices she's not going to use and I want them?
I don't plan on getting divorced, but I feel like my wife would get the spices. She's got quite the collection herself. I wouldn't fight her on it either. What advice do you have for anyone listening who might be about to go through the process of a divorce in North Carolina and is going, I don't know if I need a separation agreement. What's their first step?
First step is to get a consultation with a family law attorney. You don't know what you don't know.
Right.
And it's important to talk these issues out with someone who can hear what's happening in your specific situation. We all want to get advice from friends and family, and, that advice can be well-meaning. But a lot of times you may be holding something back because you want to keep some things private. With an attorney, you can tell us everything. I tell my clients and my consultations, treat me like your doctor. Tell me everything, because that's the only way I can really give you good advice is if I truly understand what's happening in your specific situation.
Yeah, there's no benefit to the client to hold stuff back from you.
None at all. No.
Yeah. All right. Well, thank you for joining us on Advocating for Dads with experienced family law attorney Jana K. Jones. To connect with Jana, head to lawofficeofjkj.com. And please like and subscribe to our channel and leave us a review if you get a chance. Jana, always great to talk to you. Thanks so much for being here.
Thanks so much.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.